Healthcare is no stranger to any of us. Whether we are providing it or receiving it, confidentiality is paramount. Fortunately, there is a practice in place to protect us. In 1996, the Health Insurance Portability and Accountability Act was signed into law. The law, more commonly known as HIPAA, protects the privacy of every medical record and strengthens every individual's control of personal health records by giving us greater access to our personal health information and greater control of its use and disclosure. HIPAA has been updated several times over the years, including through the HITECH Act of 2009, which increased penalties for non-compliance and imposed stringent requirements for data breach, and through the final Omnibus Rule of 2013, which strengthened privacy protection to its greatest level yet. HIPAA is a rule that is important to all of us because we all have personal health information. Protecting this information is one of the most important duties of any healthcare professional, not only because privacy is a sacred right that we all cherish, but also because it is federal law and is therefore mandatory. There are severe civil and criminal penalties for non-compliance. Anyone who obtains or discloses protected health information by deliberate neglect, for personal or commercial financial gain, or for any other malicious purpose may be subject to termination, demotion, suspension, hefty fines, loss of license, or criminal prosecution. Protected health information, also known as PHI, is health information that can be connected to a person. In other words, if any identifying information such as name, address, birth date, or social security number is connected to health information, then it is protected by HIPAA. Covered health information includes past, present, or future health conditions, how the health care was provided, the payment history for the health care, personal information such as name, address, social security number, birth date, and billing information. HIPAA covers the protection of this information when it is used or disclosed orally, written, or printed on paper, and when sent electronically. The best practice when dealing with health information is to automatically assume it is protected by HIPAA until you are told differently by an expert. Organizations covered by HIPAA are called covered entities. A covered entity is essentially any organization or individual who has access to patient records. These include healthcare providers, health plans, healthcare clearinghouses, and business associates. Business associates are organizations or individuals who provide services such as claims processing or legal and consulting services. A business associate is covered by HIPAA if their work involves access to protected health information or the use or disclosure of protected health information. When a covered entity hires a business associate, there must be written safeguards that detail PHI use. The business associate is subject to the same HIPAA rules as any other covered entity and cannot be contractually authorized to violate the rule. How is protected health information protected? In many cases, it requires written authorization from the patient or a patient's family to use or disclose PHI. However, HIPAA was never intended to get in the way of prompt and effective medical care. Consequently, there are several scenarios when this authorization is not required. When treating a patient, the full record of an individual's medical history is needed to provide the best care possible. Therefore, permission is not needed when PHI is accessed by professionals directly involved with the patient's medical care. And can you imagine what a nightmare it would be if healthcare facilities were required to have staff get permission for every action they took? Thankfully, they don't. No permission is needed to use and disclose PHI for healthcare operations and billing. Healthcare workers who receive PHI in these instances should make privacy their paramount concern and do everything in their power to keep the information private. There are some situations, however, where complete privacy is not possible. HIPAA calls this incidental exposure. In these situations, medical professionals should take reasonable care to keep information private. When discussing the treatment and care of a patient, try to avoid public areas like waiting rooms or elevators. If this is not possible, then avoid using the patient's name. If the patient is not in a private room, the curtain should be pulled, and a reasonable attempt to not be overheard should be made. For instance, this doctor and nurse are discussing a patient as they walk down the hallway. However, they are taking care not to mention the patient's name, and the hallway is not busy. They have minimized incidental exposure and are not in violation of HIPAA. When using PHI, healthcare workers should use the minimum amount of information necessary to get the job done. HIPAA calls this the minimum necessary rule. The doctors and nurses directly involved with the treatment of a patient need all of the medical history available for effective medical care. However, other workers involved in the care, such as lab technicians, need a much smaller amount of the patient's personal health information. Covered entities need to establish policies and procedures that restrict the access and use of PHI to the minimum necessary. Employees who regularly access PHI need to be categorized by the type of PHI they need and the conditions for their access, so that only the amount of information they need to do their job effectively is released. In addition to patient treatment, operations, and billing, there are several other scenarios where no permission is needed to release the minimum necessary PHI. These include for public health activities related to disease prevention and control, to report victims of abuse, neglect, or domestic violence, for audits, legal investigations, licensure, law enforcement purposes, and government functions, for coroners, medical examiners, funeral directors, tissue organ donations, and certain research purposes, when requested by employers for a work-related illness, injury, or medical surveillance to comply with OSHA, MSHA, or a similar state law, to avert a serious threat to health and safety, and as a limited data set where all personal identifiers have been stripped out. Finally, minimum necessary PHI can be used or disclosed without authorization, but with patient agreement to maintain a patient directory, to inform family members about care, location, condition, or death, and inform agencies during disaster relief. This can be accomplished by getting simple verbal consent from the patient. In emergencies when the patient is incapacitated or otherwise unable to consent, you will have to rely on your professional judgment to determine what is in the best interest of the patient. For example, it is usually permissible to release information on the patient's progress to family or friends who accompanied the patient to the hospital. However, if a family member arrives after the patient has been admitted, it is important to check identification and to review the facts of the case before proceeding, especially if there is evidence of domestic violence or abuse. Let's look at some scenarios that could occur in a healthcare environment. This doctor is relaying test results to a patient's spouse. However, he is giving the information in a waiting room where he can be overheard. In addition, he has failed to get agreement to share this information from the patient. Both acts are a violation of HIPAA privacy. Remember, when giving PHI to a family member, first make sure that you receive approval from the patient to release the information. Then make sure that you give the information in the most private manner available, preferably in a private room or in a private area where you cannot be overheard. This doctor is giving information about a patient's status to several family members. The patient is incapacitated and cannot give permission. However, the family members shown brought the patient to the hospital. The physician has used his professional judgment that releasing the patient's PHI is in the patient's best interest. He has also taken care to bring the family members into a private room. So what about telephone calls to patients? HIPAA allows for healthcare providers to communicate with patients by phone or mail. When leaving a message on an answering machine or with a family member or other person when the patient is not home, take care to leave the minimum amount of information necessary. For example, leave only your organization name and phone number and ask for a callback, or leave the minimum amount of information necessary to confirm an appointment. For all other uses of PHI,